I'd like to do three things before getting into my actual presentation. First, I want to thank the organizers, especially Tim Reese, who contacted me, also Donovan, and I happened to speak today to Shane Cobb Adams at Iolani Palace right before getting on the plane, so I know he was involved as well. But all the organizers of the Halawai okoa, it's really important work that's happening. It occurred to me this is the only major island without a four-year university, so we, on Oahu, we take for granted that there are presentations all the time, but these people have taken it into their own hands to sort of do popular education, which is a kind of a radical idea in itself. So mahalo nui loa. And mahalo everybody for coming on this night. The second thing is to introduce myself. I don't assume that everybody knows who I am just because I have a blog. You know, they say about bloggers, never have so many said so much to so few. But that has really taken off, and I think it's because of the lack of good information that's out there. So just a little bit about myself. I was actually born, I want to thank him for his amazing presentation as well. He mentioned Massachusetts as being the first place for compulsory education. I was born there, actually, to a Hawaiian mother, a graduate student, and a father who is one of the original descendants of those pilgrims, basically. That's the Perkins side. But I moved here when I was 2. My mother was a fellow at the East-West Center, and if you think about Barack Obama's upbringing, mine was very, very similar. My mother was a East-West Center fellow, graduate student, sometimes on food stamps. I went to Noelani Elementary like Obama. 10 years later, I'm 10 years younger. And then at 9 years old, I moved to a third world country. And then I came back for high school. He moved to Indonesia, I moved to Tonga. So in a way, that was a formative experience. I mean, that was my formative years. I was there for 6 years in Tonga, and you know, my favorite writer, Colm Toibin, says that he grew up in the 1800s, and because he didn't have hot water and all these things, growing up in Ireland, and I was kind of the same way. The tourist slogan for Tonga is, visit the 19th century, come to Tonga. So I kind of had that experience of living in a Polynesian monarchy. And Tonga's monarchy is a constitutional monarchy modeled very much on Hawaii's constitutional monarchy. The Constitution of Tonga is, in some cases, word for word, directly from the Constitution of 1840, the Hawaiian Kingdom. So I came back in the mid-1980s. The school Lahaina Luna was mentioned. I went to that school about a century after its heyday. But when Kaho'okahi was, let's see, what was he doing? Oh yeah, being born, I was graduating from that school in 1989. Actually, in 1989, I was here on Kauai running the state cross-country championships. And I've only been here, this is only my second time since then, so really happy to be here. I went to college in California, and then I taught at Waianae High School, and I actually went back to Lahaina Luna and taught there. That's where I first started teaching Hawaiian history. And then I went to Harvard, and I was in Massachusetts for about 3.5 years, and then came back and immediately started teaching at Kamehameha. So I've been teaching at Kamehameha now for 14 years. And then along the way, I've picked up other positions as a lecturer. I teach at Windward Community College and UH Manoa. I teach a class on occupation there, so if anybody wants to talk about that, that's one of the only classes in the world on that topic of occupation, military occupation. As far as my family, actually I'm going to get a little bit into it, but he had he had a slide that said that Kauai was, I think it was Aina Nui Makekau, and Makekau is my last name of my great-grandmother, so I'm a Makekau. I'm also an Apo, not a popular name in the sovereignty, the independence movement these days, but you know, we have a lot of awkward family dinners and agree to disagree. So the title here is the title of my PhD dissertation, which I finished about 3 years ago. But before I get into that, I just wanted to point out that the picture there is, I'm pretty sure it's Kauai. It's Limahuli Stream there on the side. But that's what Kuleana land grants kind of look like. They're these often landlocked parcels. And that was part of the long story of their being kind of alienated. The third thing I wanted to do before starting was just to honor maybe the godfather of our movement, the father of our movement, Kekuni Blaisdell. I just came from Iolani Palace directly. And they were having the sort of ceremony to honor not only Kekuni, but Puhi Pau. Anybody seen Namaka Oka'aina videos? He's a producer. And then another woman who's been active in the Makua struggle, Leandra Vai Rodriguez. So the three of them kind of passed within the same about a week. So this is the movement's kind of recognition of them that's still happening right now at the palace. There's a picture of, ironically, Kekuni interviewing me about, it's almost embarrassing to say that, but about globalization. That's me with a little more hair. In 2011, around the APEC meetings. But I just want to show you a little quote that came out in a very timely way. It was a review of a book that I wrote a chapter in this book here, Native Nations. It's about indigenous people around the world, and I wrote the chapter on Native Hawaiians. And in that chapter, I talk about Kekuni. And then this quote here was in the review of the book in the journal, the Contemporary Pacific, the main journal in Pacific Studies, I would say. So I just pointed out that I don't know Kekuni as well as some other people, but I've known him for a long time, and I've known about the movement for a long time. So at age 16, I went to a very early sovereignty rally, and this idea of sovereignty was incredibly radical at the time. And I said in the article, in the chapter, you know, here was a Hawaiian, very successful in the newly westernized Hawaii, advocating the idea of not being American at all. So that's in 1988. Within 5 years, by 1893, the idea of sovereignty would be attained in some form was almost considered inevitable. Some people might take issue with that, but the Honolulu Magazine, which is kind of the magazine of the Kahala Mall set, even they were saying, well, it looks like sovereignty's right around the corner. By 1995, we're going to have it. And then in 2005, around there, they had another article saying, what happened to Hawaiian sovereignty? It's a good question. My own view is that if sovereignty is like the pinnacle of the pyramid, everybody wanted that, but they realized they had to go down and build up the foundation. And the foundation is the work that everybody's doing now, working on language, working on native tenant rights, working on economics, working on health, working on education. So it's been and I realized just coming here that we're kind of now on the fourth generation of sovereignty activists. If Kekuni's the first, he's, or you might say fifth generation, he's World War II. He actually picked up a gun on December 8th, 1941 as a senior at Kamehameha and went up into the hills to look for Japanese who might have parachuted into the mountains and tried to poison the water supply. So he's World War II generation. Then we had baby boomer generation like Haunaniki Trask, John Osorio. Then we have my generation, for better or worse, Generation X. You know, we don't really know who we are. The X is the unknown factor, so we all go into Hawaiian studies or ethnic studies to try to figure out who we are. And then now we have the millennials with Kaho'o Kahi kind of very much at the forefront of that. And we're looking at a multi-generational movement now. And it just kind of occurred to me sort of on the trip here. I think it's pretty profound. So really what my project is about is asking the question, how did we go from this to this? In this picture, what I'm seeing is there are some boundaries, there are some palena, but most of the understanding of land and how it's divided up and how it's used is in the mind of those people there. It's in the mind of the chief. You can't see them on the land, and there's a kind of a connection between the people and the land. Does anybody recognize this? Yeah? That's here on Kauai, right? I figure there's a river, so I figure it must be Kauai. Wailua? Waimea? So what I'm seeing here is the boundaries are now visible on the land. It's fenced off. But more than that, the land is being used for productive capacity to sort of enrich its new owners. And so this notion of ownership is something I've thought about a lot. And so if you boil my project down to the basics, it's really about the difference between these two pictures. So I said I would talk about my family. There's the original owner, the original. Oh, I should just say, in my project there was the thing was, I didn't go into land research for my own benefit. I didn't do it so that I could find out if I owned some land. I knew about this land, but wasn't the purpose. I'll talk about what the purpose was later. But since going through it, I did find the maps of the family land. That says Male or Mele, it's Mary Makekau, and her heirs. That was the larger map. The one on the bottom, Mima Apo, is my great grandmother. That's how I'm an Apo. And so that parcel of land, actually, my cousin lives there, and she actually rents from other relatives, so it's still in the family. But that wasn't really my purpose for doing the research. And so that has an advantage and a disadvantage. The advantage is I have some distance. I'm not personally trying to have it come out a certain way. The disadvantage is when you're tied to it personally, you're more likely to just keep digging and digging. And what I'm finding is that there's always more to find when you do keep digging. So since I finished the dissertation, I've found things and I've had to adjust my thesis. And I'll talk about that. So if you look at sources on traditional Hawaiian land tenure, you usually find about a paragraph. They talk about very, very briefly Ahupua'a system and how it was feudal or similar to feudal, medieval type European land system with layers of ownership, with a lord who subleases to the vassals and the serfs. those are the tenants at the bottom. And then they kind of just move on to talking about the mahele. And so in my project, I wanted to try to expand on that. So I actually did a 30-page chapter on traditional land tenure. But this quote kind of sums it up, that that what we've been told so far is much too simplistic a picture of traditional Hawaiian land tenure, and there's a lot more research that should be done. And I'm hoping mine is a contribution to that. But I really wanted to honor that system that was already there before this new system is created. So my degree is in political science. I'm looking at the politics of land. And to me, land it's not, when we say malama aina, it's not always just sort of tree hugging. It's also a means for building up the capacity for warfare. It's the opposite, you might say, of tree hugging. It's the foundation of power. So land is power in Hawaii. That was true in the time of Mano Kalanipo and Umi, and this is a quote from the time of Umi, and Kamehameha, and up till today. With the development of Kaka'ako, we're seeing that land is still power. So this quote, I'm not going to read, I have a lot of quotes here, I'm not going to read through them, just paraphrase, but in the story of Umi Aliloa, he uses land and agriculture as a way to build up an army. He feeds men. That's what gives him power, that's what gives him followers. And so the land is what creates power. And then a new model is imposed on Hawaii. Well, I wouldn't say imposed. The traditional sources say it was imposed. It was this Western construct just kind of dropped on Hawaiians. But my view is that it's actually co-created, that Hawaiians and foreigners, their allies, create the system together, and it's actually a hybrid system. It's not just an American system. The traditional critiques, and my work is a new view of the Mahele and Kuleana Act process. Traditional critiques say, it should have looked like this, and it ended up with that Makainana slice being less than 1%, 0.8%. But I'm arguing that's actually not true. The Privy Council said, if all parts were equally valuable, it might be divided into 3 equal parts. It's just a theoretical idea that it could be divided into 3 equal parts, but it was never meant to actually come out in a pie with 3 equal slices. In fact, one of the things I'm arguing is that land is not a pie, it's not 2-dimensional, it's 3-dimensional. It's not a pie, it's a layer cake. Just to give you a visual. And so the three are not slices, the 3 owners of the land, the 3 owners of all land in Hawaii, the king, the konohiki, and the ho'aina, are not 3 slices, they are 3 layers. So it doesn't matter what slice you take, the slices on the top that's ownership of land. But the rights to land are the layers. And so the 3 are layers. So it doesn't matter if you take a small slice, like the green one there, or a huge slice, like the yellow. Whatever slice you take, it has the 3 layers in it. So it's like a layer cake, chocolate, vanilla, strawberry. It doesn't matter what slice you take or how big it is or how small it is. There's those 3 flavors within that slice. What that means is, at the minimum, Makainana own a piece of your land, of your private property. And so private property in Hawaii is not the same as it is, say, on the continent. That was already admitted in 1995 by the Hawaii Supreme Court, the state of Hawaii. It's not the same. There are these rights in it. Now, that's where we get to this sense of rights. kuleana. There's a sign right here that says kuleana, be responsible. Well, yeah, that's one side of the meaning. The other side is rights. So, I teach teenagers. I just became the father of a teenager. My daughter just turned 13. So I'm always telling kids, you have these rights. You need to practice the accompanying responsibility. And that's the story of being a teenager's parent, right? Here's a right, you have a responsibility. For Hawaiians, it's the same word. So I really appreciate Kaho'okahi's presentation because it's really about the meaning of words, and that's been extremely important for us because the history of the last century of what we've been told about Hawaiian history has used a lot of these words incorrectly. He brought up the Andrews Dictionary, and I find that dictionary incredibly valuable in a lot of ways, but especially in the definition of kuleana. There it is, word for word. A portion, a right of property. One's appropriate business. And then in a note, in modern times, it refers to a small land claim inside another's land. Now, you can't get more clear than that. Kuleana, or what we call native tenant rights, the name native tenant rights is kind of misleading. First of all, the word tenant makes you think of a renter. And Hawaiians were, in a sense, living on land at the will of the chief. So we're similar to renters in that way, but a renter doesn't have the right to that land. And Hawaiian Makanana did. But there it is. You're living on the land and they're calling you a tenant, but no, you actually own that land. You just haven't been able to, you just have to go through a process to turn that right into an object. Okay, so that's a central piece of what I'm saying here is a right is turned into an object. It's pretty basic, but tomorrow is the Democratic caucus, and you have the right to vote. Does that mean you did vote? That means you can vote, and once you do vote, you give up the right, and you got a thing, you got an object, you got a say in the election. So it's the same here. The layers are the ability to divide out and get a piece of land, and the surface of the cake is the actual land itself. So it created a system that looked something like this. Now I had to stretch my technological skills to the limit to create this chart, so hope you appreciate it. What we've got now is multiple layers of land. Land is a multiple layered thing. So we usually think of land ownership, we're thinking about that middle layer that has three types of ownership there. Fee simple, most people know about leasehold, and maybe some people know about life estates. It was the right for your lifetime. It didn't go down to your heirs. It was a type of ownership. But that's that middle layer. Beneath that, and I would say it means more fundamental, is the actual the source of power that allows people to own land at all, and that is called dominium. Now that's a tricky word that I'm going to talk about, but it's at the level of dominium. It's at the level of the sovereign's ownership of land, that we have these three owners: the government, Konohiki, and Ho'aina. So Konohiki is the chiefs. They got land in their capacity as the managers of land. And Ho'aina Makanana got land because they were the ones actually cultivating it, because they were practicing their responsibility. They had the right. It's all together in one. Now, what's happened with the word native tenant rights is it's been used to look at that highest level, which is the most, I would say, I don't want to use the word superficial, but it's the least solid, and that is the gathering rights. and access rights. And what the Supreme Court did in the Pash decision of 1995 is like a sleight of hand. They said, look over here, you have these gathering rights. Aren't we liberal? Right? You have the Hawaiian judges on these things and saying, look, we're giving you these rights to access. We're giving you the right to gather. We're so cultural. And the academic word is it elides, it hides the fact that there's this more fundamental right at the bottom. Never mind usage, you own that land. So that's been an incredible sleight of hand that's been pulled on Hawaiians. Just a word about dominium. People probably know about the idea of eminent domain. You're going to be hearing more about it because rail, as it goes into Honolulu, is going to be exercising eminent domain. The sovereign, supposedly state of Hawaii sovereign, has the right to seize your land. What is that right based on? It's the original word for eminent domain is dominium, eminence. They can do that because supposedly they have the dominium. They own it at the level of the sovereign. Dominium is a tricky word. It goes back to Roman times, and it's somewhat evolved over time, and it's not very well understood, but it's a good word to use for this layer of land ownership that we're talking about. Sovereign ownership. If you ever do a land title search, if you do it correctly, you're supposed to trace the ownership back to the sovereign. Back to the sovereign. Land title companies are not doing that today. But that's they've admitted that that's what they're supposed to be doing, because the sovereign is the original owner of all the land. This is in pretty much every country in the world. In Britain, it's the same. In the British Empire, the government owns all the land. So the largest landowner in the world is Queen Elizabeth II, because she owns, at the level of dominium, all of the United Kingdom, Canada, New Zealand. I mean, she owns that as the sovereign, right? Queen Elizabeth is the Queen of New Zealand, right? She's on the Canadian money. And that's why their ownership is not called fee simple, it's called freehold. You hold that as a free person at the will of the sovereign. She's the actual fundamental owner. Same thing here, except in Hawaii, it's not just one person, the queen, it is three owners, the three classes. It's extremely profound. Okay, and this was made very explicitly clear on every original land title document, the royal patents. They all said that they reserve the right of native tenants. Now, that's actually a bad translation. It says, "Na kuleana o na kanaka ma loko," meaning the rights are inside the land. Yeah, that's reserving the rights of native tenants is kind of a sterilized way to translate that. Yeah, the rights are ma loko, inside. Okay, one thing I've been struggling with over the last 2 years is this question of a deadline. A lot of the sources you look at cite the deadline as February 14th, 1848. February 14th, 1848. I was glad that we had a nice timeline in the last presentation, because I'm not really going to do that. But the Mahele happens in 1848. The Kuleana Act, which gives Makainana the right to claim lands, is in 1850. So it doesn't make any sense to have the deadline for dividing out your interest 2 years before you've even passed the law. It's just like, remember Kauinoa? Kauinoa, they said, sign up for something, we know not what, right? Sign up for saying you're Hawaiian, because in some future date, we're going to have some kind of process that's going to create a Hawaiian nation, we hope. Come to find out, it's not Yaupuni, and people are trying to get off the list. And they were rolled onto the list through some legislation. This was similar. If that was the case, it would be similar. But here's the thing. It's not true that that was the deadline, because it says in the statute, we will confirm or reject all claims to landed property acquired anterior to the passage of this act. Now, a lot of people just assumed anterior meant after, because it seemed to make sense. But anterior means before. Before 1848. So what that tells you is that there's land ownership in Hawaii before the mahele. Actual deeds. And I actually found in the Bishop Museum 2 land deeds signed by Kamehameha III and William Richards from 1839, well before the mahele. So that's what that deadline is for. Deadline is for a few, mostly foreigners, who had been given land by chiefs, and they had managed to get some kind of, they wanted to see some kind of documentation. So basically they're saying, we don't want to go out and distribute lands until we know who already owns some lands. There wasn't that many, but there's a few. They don't want to give away somebody's land that's already owned. That's what that deadline was for. And so that argument is out the window. And this is something that I should have found originally, but I only found recently, is that there was actually a much more firm deadline, which was the 1st of May, 1854. So in a statute in 1853, the legislature said, all claimants of land have to prove their claims by May 1st, 1854, or you shall forever be barred from proving the same. And so that seems like a much harder deadline, right? It seems like that's it. In fact, that is the deadline that most of your lawyers who are working in the land court would use. They would say, I actually had a debate with a lawyer who works in the land court. I'm going to talk about the land court. And he said, no, there was a deadline. I know there was a deadline. He couldn't remember what it was, which tells you something. But he said there was a deadline, and that's it. The problem is that deadline was extended and extended about 6 times, all the way until 1909. So we're talking about well into the territory of Hawaii. And that brings me to one of the points of why I got into researching land instead of one of my main interests is sovereignty, is that land is it's a solid system. In other words, the land system in the kingdom is the same land system now. There's absolutely no break with the overthrow. The overthrow doesn't break land titles. When I teach this at Kamehameha, I say, where's the evidence that land titles weren't broken? It's right here, it's the floor, because this is Kamehameha Schools. We own this land from 1848. It went from Moses Kekuaiwa, I teach at Kapalama. The ahupua of Kapalama went from Moses Kekuaiwa in the Mahele, that's the brother of Kamehameha the 4th and 5th, to their father, Kekuanaoa, back down to Kamehameha the 5th. He died with no heirs, to Princess Ruth, and then part of the large set of lands of Princess Ruth gave to Pauahi, and then it became our campus. So it's an unbroken chain. So theoretically, the argument that William Richards was making at the time, that if you create private property, then any overthrow is not going to affect those titles. Theoretically, it was correct. It's just that in so many cases, they found ways around. They found ways within the system. Often it was foreclosure, which I'll get to a little bit later. But theoretically, it seemed to be right. You can keep the ownership of the land in the hands of regular makainana, and that's, if there's only one thing more important than sovereignty, it's the livelihood of Hawaiian people, right? But that gets me to this, when I got to the end of my research, I started to realize it's actually kind of circular. It goes right back to sovereignty again, because I thought that I was looking at something that was really black and white, that, okay, you have a land title, either you own it or you don't. But the fundamental power that allows such a system to exist is sovereignty. And if that sovereignty is questioned, which it is right now, then we're back in the paradox again. So it's not as black and white as I was hoping it would be, but more interesting maybe. Now, I said that my work is a genealogy of native tenant rights, and I mean that in a specific way. This is kind of the theoretical part of my work. You know, there are other people working on this, like Donovan Preza. People may know his work. He's working in geography, but my work is, in a sense, it's political theory. So I had to have a really sort of philosophical framework through which I look at this problem, and that framework was one that I would say helped to create, which is a hybrid genealogy. It means genealogy in the Hawaiian sense of basically sequence, but it also means the opposite of sequence, breaks and ruptures, and that's what I'm going to talk about. What I found is that Hawaiians are surprisingly comfortable with multiple versions of stories. There are 13 versions of Pele and Hi'iaka. There are multiple creation myths that they don't have a problem with saying this one might be right, this one might be wrong, and we're okay not really knowing. So my method is not so split into two as you might think. Those two kind of work together. I'll explain. So here's a genealogy of the legal foundation of Hawaii in the different governments. So starting with the Constitution of 1840, this was Lauren Thurston. He says that it goes through the different constitutions, and then the provisional government, the republic, the treaty annexing Hawaii, the resolution, the ratification of that treaty, and then the joint resolution of annexation. Okay. You don't have to know anything about Hawaii's history to know that Hawaii was not annexed twice, right? It was not annexed in 1897 and 1898. That's obvious, it's self-evident. But Thurston is trying to legitimize what he had done in 1893, and then what was continued in 1898, and he benefited from, which was really treason, right? And he admitted everything he did in 1936 when there's a bunch of ships in Pearl Harbor, and he can just say it out loud. But if he had admitted what he had done in 1887 with the Bandit Constitution, 1893, he'd be hanged, because treason is the highest crime. It's worse than murder. It's murder of a country, right? And so this is an effort later in his life to cover up what he had done. Now you might think, oh, Thurston, you can just sort of, everybody knows, you just dismiss him. Well, that's not the case. This book of his was cited in the case Doe versus Kamehameha. And both sides accepted that. And yet, this is what we're seeing. So that double annexation there is a rupture. This is not a linear, this is not a sequential chain. It's fractured. And so part of my bigger argument is that a lot of Hawaiian history, what we've received, the sequences of this happened and this happened, these timelines are fraught with these kinds of ruptures. So here's another genealogy. Just to note for people who are into these things, when I use the term genealogy, it's the philosophers Friedrich Nietzsche, the German, and Michel Foucault. They worked in different times to create this idea that the effort to try to trace back to some kind of beautiful origin myth is a very problematic thing. And often we find there are these breaks. in the time of Nietzsche, evolution was just being discovered. So the idea that there's this beautiful origin myth, he's saying, no, you trace back, it goes to apes. So no further in this direction. Anyway, that's just an aside. When I say genealogy, it's the opposite of what you would normally think. So we all know Okahi from the Mauna Kea struggle, and Mauna Kea is ceded lands. Now, here's a genealogy of the ceded lands, crown lands specifically, but I don't know if people know the word ceded means transferred, typically by treaty. Now, everybody knows there was no treaty. Even the head of the Pacific Command at Pearl Harbor admitted there's no treaty. So no treaty, no annexation, no treaty, no ceding of anything. There are no ceded lands. That's why they're started to be called the seized lands. So here's a genealogy of those lands. So they go from monarch to monarch, starting with Kamehameha III, because he gets them in the Mahele. Kamehameha IV had to go to court to determine, Kamehameha V had to have a little court battle with Queen Amma, who was the heir. But it continues on. It's an interesting kind of land title. It's not fee simple in a normal sense. The ceded lands, the crown lands are a special kind of land ownership that passes to the next monarch. Keanusai has used this really pretty outdated term, but I think useful term called fee tail. Fee tail. Because fee tail means it doesn't pass to all the heirs of your body, it passes to one specific heir. And so that's the case in the crown lands. In 1865, this in these court cases, there were some issues where Kamehameha V was going, he was kind of drowning financially. They made the crown lands inalienable. And then as time goes on and the overthrow happens, Lihue sues the United States in 1910 for her share of the crown lands because they're her private property. The crown lands are private property. And so what the state has done, where it's mashed together public lands, the government lands, and private lands, crown lands, just smash it together into one body of land called the ceded lands, it's extremely problematic because they're private lands. I know that because I looked with my own eyes at a book, a ledger of those lands, and it says private lands of Kamehameha IV. So it's private. So Lihue was suing the government, and in that lawsuit, they said, going back to this 1865 statute, that makes these lands kind of public. And that was their not very strong argument for sort of turning these private lands into public lands. Now, the overall strategy from the time of Kamehameha III with William Richards was something that's been called the three paths to Western mana. If you want to be recognized by the West as sovereign, as civilized, you need three things: Christianity, Western government and laws, like a constitution, and capitalism. Now, a subset of capitalism is private property. Some scholars in New Zealand, very, very reputable, have said, and many others have said, private property is the very foundation of Western civilization. Like, you think of Western civilization, you might think of museums and, some art and some nice architecture and all these things. But if you boil it down to what it's really, really about, it's about fencing off a piece of property and saying, this is mine. Not only I say it's mine, everybody else agrees, and the government is going to defend my right to this land. That's what private property is. It's a right. It's not actual ownership. It's a right that the government protects. And yet here's the U.S. Supreme Court saying, no, we're going to turn your private property into public property. undermining the very foundation of Western civilization itself. As you can see, these things are, it's fractured. Our narrative that we've been told is absolutely fractured at so many points. So much so that Van Dyke, who is pretty moderate, mainstream liberal, said that the fractures here are so extreme, we should just accept that these lands should be just given to a native Hawaiian governing entity. This was in 2008. He was just imagining what that might be. But he's not a radical. He's a mainstream person, mainstream lawyer, saying that's how ruptured this is. Okay, I don't want to get too much into this, but this is another part of the theoretical aspect here. There was a kind of an indoctrination that was happening where they were teaching the chiefs capitalism basically as a moral system. In fact, the guy who wrote the textbook that William Richards translated was actually a moral philosopher who wrote a textbook on political economy. And at the very beginning he says, principles of political economy are so closely analogous to those of moral philosophy that almost every question in the one may be argued on grounds belonging to the other. In other words, capitalism is the moral, it's absolutely a moral system, which, I mean, we're talking about this in the time of Bernie Sanders' campaign. I mean, everybody knows that's not true. But that's what Hawaiians were being taught. But there was pushback, as you would say. There was resistance. In some cases where they were trying to create this private property system, the chiefs in the Privy Council, king and chiefs, laughed very heartily, remarking, "So they think we are fools, that we do not know the value of our own lands." So that's why I say it wasn't just an imposed system, it was co-created, but also it was created through a kind of a tension between Hawaiian chiefs and foreigners, and even within Hawaiians there were tensions there. I can get into that, but next slide. So if anybody understood this system, it would be someone like Sanford Dole, right? He is a Supreme Court judge of the Hawaiian Kingdom. He understands the law. And so, in my view, they kind of responded to native tenant rights, which they understood were extremely embedded. They were embedded in the land system. They cannot be conveyed away. And so they responded it through different means. I've listed a few here. Non-judicial foreclosure. That actually predates the overthrow. They can, maybe somebody's even been through one. They still exist. In 2010, they very much curtailed these, but for the time in between, you were able to foreclose on someone's property as a private contract without any kind of court oversight, hence the name non-judicial. By the way, the head of the House of Nobles at the time that law was passed was Charles Reed Bishop. I don't want to go off too much on Charles Reed Bishop, but we have Charles Reed Bishop Day at Kamehameha Elementary School. This is a guy who was very much in favor of annexation. Put it this way, Charles Reed Bishop is so much more interesting than we've made him out to be. I mean, he's funding the sugar growers with his bank and married to the heir to the throne, and yet in favor of abolishing the existence of that throne. That's interesting. Let's not make him boring. There's a book about him called Heart of a Hero. I mean, that's boring. We should look more closely at him. He's interesting. Dole, a very close friend of Bishop, created the land court, which was based on an Australian model called the Torrens system. And the next slide is about that. But this is a fantastic quote. It's a bit long, but it's worth looking at. So, titles have become burdened with those elements that would make it almost impossible to buy safely. Out of the murkiness and darkness surrounding them, there hardly comes a gleam of light to satisfy those who wish to be safe in their investments. What is that? Native tenant rights. Uncertainties and technical blemishes hang like so many threatening clouds over them, and laborious searches of title are necessary to determine their status. Even then, doubt may still persist. We have experienced samples of this. It springs into vitality at the most unexpected times and strikes from hidden places. Out of the void wherein sits enthroned the heirs of John Doe, too frequently strikes a thunderbolt to scatter and destroy. Very, very dramatic language describing the problems when you're on the other side of native tenant rights. Hawaiians have these rights, which they're figuring out. They're really talking about the idea of multiple heirs, that there's always another native tenant who can come in and claim these rights. These are rights to a fee simple. They're not some gathering rights. That's exactly what they're talking about. And it says the heirs of John Doe. It really should say the heirs of Joe Kealoha. That's what we're talking about. So that was one response, was to create a system, the land court, which would basically gloss over any of these problems. So if you ever buy property, you notice that on your on the report it says registry, regular system, or land court, right? So land, it's either just regular system or it's both. So you take your piece of land, which is already registered, and then you kind of re-register it. And the land court gives you a new title. So often it would be plantations, would bring a bunch of maps to the land court. The records of the proceedings in the land court are not recorded, and they would show the maps. Maybe the person who's affected by this is there, maybe they're not, and they would just issue a new title. And according to Robert Stauffer, whose book everybody should check out, it's called Kahana, How the Land Was Lost, he says none of these land court titles have ever been overturned. So in an academic kind of theoretical sense, we would say that's depoliticizing land titles. Now, that sounds weird. Isn't politicizing them bad? No, but making them about power, that's good, because Hawaiians can say, they can make their claims, they have power to assert their claims. Whereas if you just take it to this land court and they just sort of gloss over it and give you a whole new title that can't be undone, that takes the power out of it. That makes it legal, not political. It depoliticizes it. Another response that's often cited is this law case, Dowsett versus Maukeala. And just to look at the last part, the Republic of Hawaii Supreme Court rejected the theory that native tenants could divide out their rights later in the late 1890s. And they said, even after the passage of the extremely liberal Kuleana Act, this must be considered unlawful. This is really problematic on several levels. First of all, well, it's true that the Kuleana Act is liberal. It's basically giving land for free to Hawaiians. But there's some problems, technical problems here. This wasn't the kind of land claim that they were saying that it was. And then the Republic of Hawaii is not a legitimate government to be saying that this is unlawful. I mean, William Little Lee, who was Charles Reed Bishop's best friend and a very, very talented lawyer, Harvard graduate lawyer, he said that native tenant rights cannot be conveyed away even by royalty itself. So the king can't take away somebody's native tenant rights. If the king can't take it away, how can the Republic of Hawaii, right? I ask you. So how do people lose the land? I've kind of come up with these categories. You can look through it, but in my view, foreclosure down at the bottom, legal mechanisms, foreclosure is a major method. And also important was what I would call erasure, just the erasing of actual knowledge of land. So Hawaiians might leave, come back later, or their heirs come back and they try to get back on the land that they actually own, but that land doesn't look like it used to look. It's been blended with other people's properties. All the boundary markers have been obliterated. It's just a big field of sugar or wheat or rice. So it's what I call loss of palena, loss of boundaries. You don't know where your land is anymore. Okay, so research always should generate new questions. That's the thrill of it, that it's always ongoing. How much did that kingdom system become part of the system that we're in now? I would say largely it did. It's pretty much the same system. What's the role of water? Water is another level of complexity, which I didn't even want to get into. What's the role of eminent domain? Do you know that there was a Supreme Court case about the ceded lands and whether the state owns them? It went to the Supreme Court in 2009, I think it was, and they were really asking that question. Who owns the ceded lands? And then the question of the deadline. And the last question is kind of academic. How do you situate yourself in relation to this research? Like, if you have too much of a personal stake, does it taint the results? And if you're too distant from it, do you not dig deep enough? And that's the original problem that I started out with. But as far as my project, sometimes I think of it as a kind of a guidebook, albeit an academic guidebook for people who are doing land research, just explaining the system, how it works, what are the problems with it. And initially in my work, I said that, there's a good argument native tenant rights still exist. Like, you could still claim them, but in the last couple of years, I've backed off somewhat from that, because it really gets back to the question of sovereignty, the question of which sovereign is going to allow you or not allow you to exercise those rights that you might still have. So as far as people going out and trying to exercise the rights, I would say be very cautious. There's always a question about law itself. Is law, how real is law? The philosopher I mentioned earlier, Michel Foucault, he said that I look for the blood on the pages of the law, because law is always based at some point on force. And so that's the case in Hawaii. I mean, some of the courts here have violated their own laws in order to cover up what is. It seems that way. So that's the kind of predicament that we're in. So I would say, don't move too quickly, but know your rights. Mahalo nui a oko.
All right, mahalo, Umi Perkins, and hopefully that was enlightening for you guys. Kind of clear up how the different layers of land entitlement operates under a traditional concept and idea, where the kuleana and responsibility of ownership lies with the Lihue, essentially. So we're talking about land possession, the ownership of the land being vested with the maka'ainana, the konohiki who were in place under the final owner being our monarchy. Very insightful. Mahalo nui lua, Umi, for your presentation. In closing, I'd like to offer my favorite pule. It's a pule of healing for the land, and you guys take that with you as you go, understanding that these words are basically asking for okoa's guidance, his watchful eye to be upon all of the seeds that we sow as farmers, basically, in that all of these seeds that we sow, the desires that are connected to them come to fruition and enrich all of us through all the stages of our life. E puli kako, e kia kua, e nana mai ka mau pula pula, e ola a kaniko o a palalahala a homaka i ole, a kolo pupu, a laila, na ave aku oi ike alo i a u o a kia. A mama, mahalo kia kua, mahalo na kupuna, mahalo na o makua. Amen. And with that, good night.
Famous are the children of Hawaii. Ever loyal to the land. When the uncaring messenger comes, with his greedy document of extortion. From the Big Island, Keawe answers. Help also comes from Iilani. Mano's Kauai lends support. And so do the sands of Kakuhihewa. Write his name on the paper of the enemy. With its sin of annexation and the sale of native civil rights. Do not value the government's sums of money. We are satisfied with our stones, the astonishing food of the land. We back Lihue, who has won the rights of the land. And now we tell the story again of the people who love their land. We will not rest until we have our lands.